Joe Megan, who's Public Affairs Manager at the European Movement. Joe, good afternoon to you. I mean, most countries around the world are not in the ECHR, seem to get away with it rather well. Why can't we?
I mean, most countries around the world are signatories to some form of human rights deal. I mean, just comparing us to other countries around the world, do we want to think of how we led with the creation of the ECHR? It was an idea of Winston Churchill post-war, created by British lawyers. Is this something we want to step away from and move away from and move towards UN very limited human rights laws? Or...
Well, we could have the same, couldn't we? Really, we just make our own on that. I mean, you don't have to be subscribed to the UN or the European this, that, and the other. You just make a bunch of laws that are pretty much the same. Just get rid of the bad stuff that's standing in the way of common sense and logic.
I mean, what is the bad stuff that's standing in this?
Well, if you can't kick a wrong and out your country, then that's the bad stuff, right? If it is the ECHR that's stopping it.
Well, this is my argument, is that it's not the ECHR. The ECHR provides, vital safeguards for the person against the state. These are not. These migration examples that are pulled up are things that are dealt with in domestic courts as well. This is domestic interpretation. This isn't necessarily any decisions that have happened in Strasbourg or by...
No, that's true, but they are often, a lawyer will put forward Article 8, whatever, of the ECHR and say, this is a reason my client cannot be deported back to wherever, and that will hold sway in a court, and we've seen that happen many times. It's those areas that seem to be the kind of sticking point of where that rule or that element of that rule is, right?
In the UK has been very clear, firstly in 2012 with the Brighton Declaration under David Cameron, and again in 2022. And we've also been clear in the last year with Nick Thomas-Symonds and Keir Starmer both attending a conference in Copenhagen, saying we are pushing for reform. It's not perfect. We're in no way arguing that the ECHR is a perfect instrument. Nothing is, but you don't join perfect international instruments. What you do is you try and reform them from within, try and be a part of a wider international community. We don't want to stand on our own as a pariah state on the edge of Europe that would be the only non-signatory, including Belarus and Russia.
Australia, India, loads of other countries around the world are not part of it. So, I mean, there's that.
They're not part of the ECHR. They are part of generally sector-specific areas like the United States, Canada, Central America are signatories to a similar human rights.
But would it not be reasonable to go, do you know what, this has been there like 100 years almost, and, Churchill had a hand in it, bit of an urban myth that it was kind of his deal or our deal, but he was certainly influential. And here we are years later, we're in a very different world, Joe, from where we were back then. Absolutely it served its purpose, but we would be better with an autonomous regulation. We could literally mirror all the best bits into domestic law, could we not?
I've heard this argument, but I'd be very interested to know people making the argument which exactly, parts of the ECHR they take issue with. Is it, prohibition of torture? Is it a right to family life? Is it a right to privacy? What is the sticking point of the actual ECHR?
Right to family life would be an interesting one. I don't think anybody's going to, grumble about torture, but I mean that there's already various offences that cover this stuff anyway. But if it's a right to family life, if you have done something terrible in this country and you are precluded from being deported because somebody has utilised the ECHR right to a family life, then clearly that is a sticking point in the law where the spirit of the law, as it was previously written, is now being used in a way not imagined back in the old Churchill days. Would that be fair?
Yes, possibly. But I mean, if you look at the 16 countries who have joined Britain in asking for reforms of the ECHR, is specifically targeting its interpretation and how we move forward. How we move forward interpreting things like the right to a family life. At what point do we take the rights of the state to deport criminals and wrong-uns, as you described them, versus the right to the person to have their family life?
On that point, Joe, great to have you on with us. Thank you. It is of you, Joe Megan, Public Affairs Manager at an organisation called the European Movement. Interpretation, well, he's right about that. One judge might interpret something different to another judge. Right to family life and right to not eat chicken nuggets in the wrong jurisdiction or whatever the heck it is. We've seen all manner of very strange excuses that have really been bounced off the the kind of foundations of that part of the convention, and that's the issue that's been the problem. David Bannerman is a former Conservative MEP, chairman of the Freedom Movement. David, good afternoon to you. I mean, on that point, do we need to get rid of it? Do we just need to refine it? I mean, what's the answer to this, in short?
Well, I think now we do need to leave the ECHR. I think you could get rid of the Human Rights Act. That would be a good starting point, Blair's Human Rights Act, which incorporates ECHR and British law. But the ECHR, I mean, it's very interesting. The Lord Wolfson report for the Conservatives, I mean, he ends up saying that it imposes significant practical limits to control of our borders and many other areas. It has tentacles which have gone way beyond the original plan and the original convention. And I think that is the problem.
And that's it, isn't it? But I guess the point that our previous speaker was making was that one person's line is different to another. So some would say, well, that's clearly a case where it's wrong, it's being abused. And somebody else might go, no, actually, that's fine. We need the line drawn there. Is it that? And the best way out of this would be to just get the heck out the thing and start again.
Well, you have to remember the history of the convention, the European Convention of Human Rights, which the court interprets. The convention, he mentions Churchill. Yes, Churchill was in favour of that. But what it was British lawyers actually giving the rest of Europe, based on our practice, based on our tradition of human rights, going right back to beyond Magna Carta, for example. I mean, Magna Carta, by the way, 1215, actually reinforces rights they had before then. So, you know, many of our rights go right back. I mean, it was illegal to torture Guy Fawkes, for example. The king had to give permission for torture because it was illegal then. So we don't really need the ECHR. It's gone way beyond its remit. I spoke to a German justice there in Strasbourg, and she admitted that, you know, it is about who has the last word. Well, our Supreme Court, our judges should have the last word, because otherwise it's not sovereignty.
It is not sovereignty, indeed. What is your hope that, David, that something will happen here? Because obviously it's not, as we know, it's not really in the DNA of this government to start tinkering around with things like the ECHR. You know, they are mostly pretty satisfied, it seems, with everything that goes on in that respect. So the smart money might suggest nothing's going to happen anytime soon.
Well, I'm afraid I think we've got a Prime Minister who's a human rights junkie. I mean, seems to be the one thing that really motivates him getting excited. He wrote a book on EU law and, you know, with relevance to human rights, etc. No, I'm afraid this government's very wedded to it, as is Lord Herman, many of the pals of Starmer. But progress, I mean, reform, the EU, many of the EU nations, Germany, France, Italy, Poland, are talking about reform, but it has to be unanimous on the ECHR, is my understanding. And that does sound incredibly difficult to actually enact that. So I don't have a problem, really. You know, I mean, I thought about it. I wasn't, you know, driven to leave just for the sake of it. But I think we've got to a point now when senior people have changed their minds, like Lord Wolfson. We've got actually to grasp the nettle and to get out as soon as we can, practically.
David, thank you for your time, sir. Really appreciate that. David Bannerman, former Conservative MEP, chairman of the Freedom Association. Thank you to him. 0344 499 1000.